Hello. This is exam one, part one, oral part one. Whew, all of the part ones. So it's titled Navigating Rough Waters, which is kind of a nudge to our, initial reading in the class. But let's get started on what we're going to talk about today. So, youth in action. Essentially, all over the world, all over the globe, but especially in America, environmental policies and regulations are more and more being enacted by young people. And young people are really, really interested in the intersectionality between environmental degradation and other social issues. So, how environmental degradation impacts marginalized groups more than it would impact others, how it impacts certain environments more than it impacts other environments. And essentially, all of our environmental problems that we have today are eventually going to be the problems of the youth of today. So involving them in the legal process, involving them in the scientific process is going to give them a really solid baseline for what they're going to need to fight the legal system when they get older, because Lord knows they're going to need it. So our specific example is the Held versus State of Montana case. So a quick overview. On June 12th of 2023, the 16 plaintiffs that presented this case became the first ever citizens to go to trial in a constitutional lawsuit in regards to climate change and the environment. So they presented this against the state of Montana. As a little background, the state of Montana ranks number 8 nationally for revenue received from fossil fuels and energy production. So that's pretty daggum up there. And essentially, they excluded environmental protections and climate change principles in their legislation in order to be able to issue more permits to energy companies. So, just some quick examples here of some quotes. In 1972, the state of Montana revised its constitution and put in it, a clean and healthful environment is a right to all citizens of Montana. In 2023, the state of Montana had an attorney general spokesperson to come out and say essentially that upholding this constitutional right is absurd and was a political stunt by the plaintiffs. So we see how 40 years can change the idea of politics. Let's get into the argument. So the plaintiff's argument. So again, the plaintiffs are held at all, and they are represented by Our Children's Trust, which is an organization. So they filed this case in 2023. Essentially, they filed this case under the premise that themselves and the citizens of Montana were being harmed and were being deprived of their constitutional rights of a clean, health, and healthful environment because of the ignorance and essentially negligence of the state in regards to its environmental legislation. So they represented pretty much all of Montana's population, and this is them in the picture right here, and they look very happy to be where they are, and they should be very happy. So their whole stance was challenging an environmental policy that was, obviously not right. They highlighted the explicit exclusion of climate change and greenhouse gas emissions in the MEPA, which is the Montana Environmental Policy Act. So their case was built around these exclusions and built on the fact that this law did not include guidances and protections regarding climate change challenges. And so, therefore, their constitutional rights were not fully being upheld because the specific challenges facing their constitutional rights were not being enacted in legislation. So, that is the plaintiff's argument. So, the defendants, again, this is just the state of Montana defending themselves. So, their whole argument was that the lawsuit lacked merit. The state of Montana basically presented their main defense. They had other defenses we'll get into, but this is their main defense, is essentially that this was a political stunt and constitutional rights were not being infringed upon because their employees were just doing their jobs, right? So the state of Montana employees were following state of Montana laws, and these laws were written to protect the environment and also encourage economic gain. So essentially, they argued that the court should dismiss this case because it was just an airing of political grievances rather than an actual legal stance. So the state of Montana continued to argue that the policies and legislations that were already in place were very sufficient. And essentially, the district court upheld this to begin with, right? And obviously, the plaintiffs didn't like that. So they decided to take it higher, and those courts did not see it the same way as the district court did. Another, I guess, stance, you could say, argument that the defense presented was that the amount of energy production that the state of Montana gives off is negligible in the context of the globe and what other countries and other states put out. So basically, they argued that any business that was going on in the state of Montana wasn't really going to make a difference in whether or not these plaintiffs were being affected by climate change, so why would they need to cut out their business, right? Well, this case was actually pretty groundbreaking. It has a lot of historical significance because it got, like we said, it got dismissed originally by the district court, but it got upheld twice by higher courts. So essentially, the plaintiff's argument that climate change was not being adequately addressed was upheld. So this scholars and other, attorneys and people who are real experts on this stuff, because you know me, I'm a real expert on this stuff. Um, that was I'm definitely not. But people who know what they know, and they know a lot about this case, kind of argue that this case is going to be essentially like a cornerstone to subsequent cases involving climate change and environmental rights for individuals and citizens. So they think that this is going to set legal precedents, basically, and that other cases are going to have kind of legal standing because of the upholding of this decision. So, some states in which that might actually happen. California, New York, Pennsylvania, they all have very similar environmental protections for their citizens. So if somebody were to present a claim to the court arguing something, similar to this, there's a good chance that it could be upheld on the premise that, this one was upheld. In states like Texas, though, and Florida, it would be a lot harder to prove that, rights are being infringed upon when the rights aren't explicitly stated. Not saying it couldn't be done, but it just might be a little more difficult. Um, so a very similar case that happened earlier, this happened before, Held versus Montana. The Juliana versus United States case was 21 young plaintiffs claimed the federal government was not doing its due diligence in its fossil fuel policies, and that their rights were directly being infringed upon because they did not have access to a clean environment due to fossil fuels. The defense, which is the United States, basically argued the same principles as the state of Montana, that this is just a political witch hunt and it should be dismissed, and this is just a bunch of grievances and does not have any legal standing. Well, in 2016, the court actually ruled in the favor of the plaintiffs. However, in 2020, the courts reversed that decision and the petitions to revisit that case were denied. So essentially, that case did get squashed. However, that case did kind of form a little bit of a framework for Held versus Montana. So just kind of goes to show that, just because legislation doesn't get ruled in the favor of who we think they should, or doesn't get ruled in the favor of conservation, that doesn't mean it's not important, and it doesn't mean it's not going to do important things and set the basis for other legislation and court cases. So that is pretty much that. These are my citations. I did